The U.S. Supreme Court heard a case that has the potential to have a nationwide impact on the rights of parents and religious exercise, the freedom of religion when it comes to exercising that freedom as it pertains to children's education. This was brought by a group of parents in Montgomery County, Maryland, who are asking the court to decide on this question. Do public schools burden parents' religious exercise when they compel elementary school students to participate in instruction on gender and sexuality against their parents' religious convictions and without notice or opportunity to opt out? Joining us now with more on today's oral arguments is Meg Kilgannon, Senior Fellow for Education Studies here at the Family Research Council. Meg, thanks for joining me again.
My pleasure.
All right, give us the 30,000 foot view of today's oral arguments.
Well, it was really encouraging. First of all, it was great that we played that clip of Sarah Harris as Solicitor General, because for the past 4 years, anybody listening to Supreme Court oral arguments was hearing a lot of disturbing arguments made by the Biden administration Solicitor General. So it was a big change, and one in support of these parents, which is so wonderful. So elections do have consequences. But the overall mood of the case and the mood of the justices seemed to me to be in the favor of the parents. I was very glad to hear that.
Did it appear that as the court wrestled through this and asked questions, that they're recognizing the complications that have been created by the redefinition of marriage in the Obergefell case?
Well, I don't know what could make it more obvious than this kind of case being before them. They do seem to understand that some of the justices were really honing in on definitions, and I'm not a lawyer. I'm not really sure what all the cases were that they were talking about, but they all involve religious liberty, and some of them involve parental rights. But what they really were honing in on was the fact that there is a health class that includes a sex education segment of it that's offered for the same age range of students, pre-K to grade 6, and that class allows an opt-out, and that is not a burden for the school. So they were really asking the school system to defend the fact that they've refused to let these parents have an opt-out for very similar material being presented in, say, English class. So that part of it was very clear, and they don't seem to be buying Montgomery County's arguments.
And this could have implications nationwide, could it not?
Absolutely could. It absolutely could. And we're going to see more of this, Tony, because like you said, we haven't had this conversation. These are things that have been imposed by the courts in terms of Obergefell and its ramifications, and so we're going to have to work all of this out.
Meg Kilgannon, always great to talk with you. Thanks for giving us an update.
Thanks for having me.